There you go. Good evening, everyone. Thank you for joining us this evening. Um, Welcome to our second Race Equity Policy Series on prosecution, examining the impact of criminal justice policies on Black, Indigenous, and people of color in the court system, brought to you in partnership with Suffolk University. The Boston Debate League's mission is to integrate argumentation and competitive debate into Boston, Chelsea, and Somerville public schools to develop critical thinkers ready for college, career, and engagement in the world around them. We've been thrilled to partner with Suffolk University in this mission. In addition to our work together on this Race Equity Policy Series, Suffolk has hosted a group of BDL debaters annually in a dual enrollment program where students further develop their research and argumentation skills while earning college credit. All of this is still happening right now. Students are participating virtually and will make their final presentations in the next week. And we're thrilled to be working with Suffolk in this way. And grateful that our partnership with Suffolk to launch this series of conversations to explore the multiple facets of criminal justice reform, from policing to sentencing to community activism. And in this year-long series of dialogues and learning opportunities, we hope to connect the broader Suffolk, BDL, and Boston communities to policy leaders, change makers, people impacted by and involved in the criminal justice system, and those who advocate for a diversity of policies and practices. Now, before we introduce our panelists for this evening, just a few things to note. We do have Spanish language translation. For those who are interested, you can click on the interpretation button at the bottom of your screen, and that will bring you to the Spanish translation. We ask that everyone please mute your mics. And lastly, we do want to hear from you. The chat is open, and we want to know where you're joining us from, what neighborhood or what school. We do have Boston Debate League staff in the chat, so you'll be hearing from them this evening. And please put your questions in the question box. We know that we're joined by some BDL debaters and Suffolk University students this evening, so please indicate that in your questions, because we want to make sure to prioritize them tonight so that you can sort of have dialogue here with our panelists. So tonight we are joined by Iván Espinoza-Madrigal, Executive Director for Lawyers for Civil Rights, the organization that filed the first lawsuits in the country against the Trump administration to protect sanctuary cities, to save humanitarian protections on behalf of Honduran, Salvadorian, and Liberian immigrants, and to block immigration arrests in courthouses. Iván is an expert in legal protections for people of color and immigrants. He has filed and won dozens of life-changing and law-changing cases across the country on behalf of people of color and immigrants. He advises federal and state policymakers on the legal needs of marginalized communities. Our second panelist is Professor Kim Mclaren, Associate Dean for Experiential Learning for the Law School and Director of Clinical Programs and Clinical Professor of Law at Suffolk University. Professor McLaurin most recently served as the attorney in charge of the Juvenile Rights Division within the Queen's Office of the Legal Aid Society. And in this position, she was directly responsible for the office's representation of children involved in family court matters, including juvenile delinquency and child protective cases. She currently teaches the Juvenile Defender Seminar and co-teaches the Marshall Brennan Constitutional Literacy Seminar at Suffolk University. And lastly, we're joined by Ashley Nellis, Ph.D., Senior Research Analyst at the Sentencing Project. She has an academic and professional background in analyzing criminal justice policies and practices, racial disparities, juvenile justice systems, and long-term imprisonment. Her documentation of the prevalence of life imprisonment has served as a national resource for academics, advocates, policymakers, reporters, and incarcerated persons. Dr. Nellis is author of A Return to Justice, Rethinking Our Approach to Juveniles in the System, which chronicles America's historical treatment of youth in the justice system and the need to reorient juvenile justice practices toward the original vision. Thank you all for joining us tonight. Prosecution is a subject matter that has increasingly garnered more attention from the media as the stories of wrongfully accused individuals, many of whom are people of color, are being brought to our attention from The Way They See Us, a mini series documenting the prosecution and wrongful imprisonment of the exonerated 5 young men who were accused of a crime they did not commit and were coerced to confess to. Another example is Trial 4, which highlights the experiences of a Bostonian, actually Sean Nellis, who's wrongfully accused and convicted and spent 22 years in prison. As he fights to prove his innocence, he has exposed police corruption and systemic racism. And for the layman, it's hard to understand how someone can spend so many years in prison for a crime they didn't commit, and even harder to understand what systems and decisions along the way led to this kind of outcome. So I'd like to start with Professor McLaurin. Kim, we've all seen some courtroom TV shows that dramatize court proceedings and the trial process. And while they seem realistic, we usually only see depictions of what fits into a neat narrative arc that is appealing to the viewer and reflects the simplistic ideas about good and bad. Can you explain to us how prosecutors make decisions and what a prosecutor has the discretion to decide on and how this impacts a case from beginning to end? And I'm thinking, for example, when does a prosecutor choose to pursue a lower charge, because of the circumstances of a crime?
Thanks for having me, and thanks so much to BDL and all the work that you're all doing. I'm so proud of everything that you're accomplishing and everything that you're doing here. I'm happy to be here and answer that question and others. So prosecutors generally have a wide range of discretion. Really, what I tell my students is they have discretion from before the case even starts. So before there's even an arrest, a prosecutor is able to decide whether there will be an arrest, whether there will be charges filed, what those charges will be, and what will happen to that person who is being charged. So they get to decide whether they are going to ask for that person to be held, whether there will be bail issued, how much will they ask for in terms of bail. They get to decide what charges go down on that piece of paper, whether it's a felony, a misdemeanor, a violation of some sort. They also get to decide what plea to offer and what plea to accept. They get to decide, even once a case is filed, whether to arraign that individual or not. They can decide that we don't want to prosecute this incident, and we want it just to sort of either go away, or we want to offer an alternative to arraignment. They also get to decide whether or not a defendant will spend the time once a case is arraigned and to trial, whether or not that person will be home with access to resources, including family support, perhaps other support in terms of mental illness, chemical addiction, or whether or not, and their lawyer, or whether or not that person will be incarcerated while they wait for trial. They also get to determine and ask what conditions of release, if you are released, under what conditions will you be released? If you're a juvenile, that might include that you stay away from your best friend that you were arrested with. It might be that you stay away from certain areas in the city. That might include your school, that might include your grandmother's house, that might include the recreation center that you spend after school in. It might also include this conditions of release, things like curfew, where you can work, when you can work, whether you can drive your car. All of those can be conditions of release, that a prosecutor has a lot of discretion and a lot of say-so in what they're asking the judge. They're not the end decision maker, but they are a very impactful decision maker in this system. Finally, they also get a lot of say in sentencing, that I'm sure we're going to hear from Ashley about, but they get to, in many circumstances, ask for specific sentences, the length of time for sentencing, For juveniles, everything from how long will you be serving probation? How long will that release be? How long will the prison sentence be? If it's an adult, they get a lot of discretion in terms of that. They also get to decide whether or not, for juveniles and for some adults, whether or not the case is heard and goes through the traditional path of court, the court system, or whether or not it's diverted out of the court system and into what we call diversion. Largely, that is a decision that is made by prosecutors. So there's a lot of discretion, and I probably have missed a lot from before the case is filed through the end of the case, and then even after that. They often have a lot of say-so in whether or not a juvenile is or an adult is returned to the community and under what conditions that person is returned to the community. They have a lot of say-so in a parole revocation or parole board hearing. You will often see members of the district attorney's office testifying in those hearings. So it is a lot of discretion that a prosecutor wields throughout the system.
Thank you. And I'd like to go to Iván. A lot of the issues that may arise for lower income defendants that center around those who can afford representation. So maybe someone assigned a public defender versus someone who has access to their own lawyer, who is able to maybe negotiate a more favorable plea with the prosecutors. And your work involves fighting for legal protections for marginalized communities and advising on their legal needs. Can you explain what some of these legal protections are that you are fighting for and how they benefit marginalized communities who may enter into the criminal justice system?
Thank you, Jackney. It's a pleasure to be here with the Boston Debate League and Suffolk University. It's a pleasure to be here with the distinguished panelists, including my friend, Professor McLaurin, who just gave a wonderful overview of prosecutorial discretion and just creating a timeline, essentially, of what the process is. And so one initial point that comes to mind that I just want to put out there in response to your question is that I think there's this myth that if you have a public defender, that's bad. I don't think that's necessarily the case. I think that there are many public defenders who are deeply dedicated to the zealous representation of their clients and are highly experienced in the technicalities around litigating a case or trying to secure a favorable plea for clients. And so I think there's a lot of stigma that inappropriately applies to having a public defender. And so I just want to start right out of the gate by saying that just because you have a public defender doesn't mean that you have a lesser degree of representation. I don't think that's necessarily true. I actually think that's highly unlikely, because I've met many of the public defenders. Many of them went to law school with me. They do a stellar job, and so I just want to be clear about that. Now, you are right, of course, that that the outcome is going to depend in many aspects on the circumstances of the case, and also on what your attorney is going to be able to negotiate for you. Whether that attorney is a public defender or a private attorney is really irrelevant. I mean, it's just going to depend on what that negotiation is going to look like. And so I think a lot of factors come into that. For example, we had an incident where a young man, a teenager, bumped into a police officer in Cambridge, and the police officer was wearing plain clothing, was just like dressed like a regular civilian, And the situation quickly escalated with the officer saying, you basically assaulted and battered me. And it was just an accident. It was somebody coming in and out of a building on a crowded street. There wasn't an intent to really harm anybody. But the incident quickly escalated, and you have this dynamic, which we've seen now, especially after George Floyd's murder, where a young Black man is being charged aggressively for conduct that probably would not have been charged if it would have involved a white teenager, for example, who would have the benefit of the doubt, and it would be essentially understood that it was just an accident. The young white teenager wasn't being aggressive, but maybe in the circumstance involving a teenager of color, either Black or Latinx, that can quickly escalate. And so in those type of situations, we've worked with both public defenders and private attorneys to just get the entire charges dismissed so that there isn't any type of criminal record that could be developed. Inquiries that could be made down the line when you are trying to apply for student loans to go to college, or if your family is applying for public housing, or if you're looking for employment. These are all circumstances where these records can come back to haunt you. And so you don't want certain things to be on your record, right? Especially if you're a young person who's just starting to go through life. Similarly, for many immigrants involved in the criminal justice system, what you plead to, even if it doesn't have jail time, could be something that is a deportable offense. So you could have a collateral consequence, an immigration consequence, depending on how your plea is structured. And so these are things that are really important to keep in mind, what I will call the collateral consequences. You're not just looking to avoid jail time, you're also looking to avoid developing a criminal record. You're looking to avoid immigration consequences. You're looking to avoid consequences that can come down in housing, education, or employment, among many other areas. And so those are some of the things that I think about and that lawyers should be thinking about. And so if your lawyer is not thinking about that actively, then it's important for you to be asking those questions, for you to say, okay, this looks good, but can we talk about what's gonna happen if I apply for work? What's gonna come up if somebody runs my background? What will happen if I apply for student loans? What will happen with immigration if the person is an immigrant? These are the type of questions that as clients, we need to be asking affirmatively because it's important not just to get out of that particular situation, but also to tee ourselves up for success.
Thank you, Iván. I appreciate that. And I appreciate your sort of tearing apart the myth around the public defenders. As I opened earlier, we see these cases on TV, and you get that sort of understanding that it's bad to have a public defender, but it's great to hear that you've been in class with these folks, right? You've worked with them, and so you know that they are there to do the job to defend people, and that's great to hear.
As a former public defender, I really appreciated that.
I'd like to move to Ashley. In many of the cases, charges that a prosecutor levies against a defendant may require a mandatory minimum according to the law. And you've done research on racial disparities in the criminal justice system. For example, there's been a lot of discussion of the 1994 crime bill and its role in accelerating mass incarceration in Black and Brown communities. Can you tell us about how sentencing policies such as those included in the 94 bill, mandatory minimums are impacting Black indigenous and people of color, and how it's exacerbating the racial and ethnic disparities in our criminal justice system.
Sure, and I'm really, riveted by the comments so far. And, I'll say sort of the, one of the myths about the '94 crime bill is that it had that it caused mass incarceration. And the reality is that mass incarceration was well on its way before the crime bill. The mandatory minimums that were put into place at the federal level first started in the mid-1980s with the crack cocaine mandatories and the establishment of mandatories and other drugs. And they were further accelerated in the '94 crime bill through incentivizing states to adopt similar strategies. Strategies like incentives for habitual offender laws, 3 strikes laws, incentives to adopt truth in sentencing, which would require that an individual serve usually 85% of their sentence. And one of the stories that was told around the endorsement of truth in sentencing laws was that sentencing was somehow untruthful, that people did not know, people in the courtroom work group did not know how long a sentence would be before they imposed it, which was not true. Judges and prosecutors and defense attorneys, they work in the courtroom every day. So when a judge imposes, let's say, a 10-year sentence in the absence of truth in sentencing, he or she knows how that is going to play out because he or she works in the system. He or she knows that it's going to be perhaps a 6-year sentence. And so if they feel that a 6-year sentence is too short, they'll impose a longer sentence. So that's where sort of the judicial discretion comes into play. That was all eliminated with the establishment of mandatory minimums and truth in sentencing, which is one of the mandatory minimums. And so one of the points that Iván just made is particularly relevant here. So when we're thinking about 3 strikes, habitual offender laws, and the impact that they have on Black people, especially people of color generally, the reason that they have this impact is that African Americans are more likely to have those initial encounters with law enforcement where it's a brush against an off-duty police officer that turns into a criminal record, and that becomes 1 strike. And so then if they do get engaged in criminal activity, they're further along the path already because they've had that original strike. And so that's one of the ways that people get brought into the system more at a quicker rate when they're people of color. And prosecutors know about all of this at the start. And I think one of the issues that is really important with this is that prosecutors, in addition to being aware of everything that happens and being, a sort of behind the scenes negotiator, they're elected most of the time. And so they have a constituency that they have to respond to. And oftentimes that constituency, their voters, they don't have all the information. They have the news, they have news shows, and they have sort of a biased picture of the criminal justice system, and they vote on that on what they see. More often than not, people in the system, in media are people of color, and so there's this sort of assumption that you know, that the criminal justice system is a different one, you know, than the one we actually have. And so, you know, prosecutors today, they have a lot of the tools that were put in place by the '94 crime bill and amplified by the crime bill. You know, there's 3 strikes and truth in sentencing, the abolishment of parole in about a dozen states, certainly the building of more prisons. But just because they have these tools doesn't mean they have to use them. And I think what we're seeing more recently is the emergence of the progressive prosecutor, and the prosecutor now who is not trying to get elected on the message that they're the toughest person out there, and that they're going to throw the book at every person that comes in their path, but someone who is willing, if not eager, to scale back mass incarceration. And it's a small group of progressive prosecutors, but it's a group that's more vocal, I think, in every election, in this past one as well. So I think there's, you know, reason to be cautiously optimistic that, you know, that there's change on the horizon. And, you know, there's certainly more that we can do in addition to voting, you know, some prosecutors out of office.
Thank you, Ashley. I'd like to go back to this thread. You mentioned the challenge of being an elected prosecutor, and Kim having served in that role. Can you talk a little bit about what that challenge looks like, particularly with the constituents who are maybe thinking more about safety, but, you know, I think in your unique perspective, you dealt with sort of protecting young people. And so can you talk a little bit about what those challenges can look like for an elected prosecutor?
I'm sorry, Jackney, did you want Iván?
Oh, either, yes, either you or Iván.
Oh, I didn't realize it was aimed at me too. Okay, Professor, do you want to start first, and then I can.
Okay. So as you know, the tension is that what the voting population or the constituents might want is somebody who is going to just lock everybody up, and not really. And this is more, I think, the old school. I agree with Ashley. I think a lot is changing as the general population gets more educated in terms of what a prosecutor does. So I think, but generally, that's the tension, is that there is a community who needs prosecutors to be fair, just, even-handed, equitable, and all of those things, and also attentive to needs that poverty, mental illness, and drug addiction brings, particularly in communities of color. And then there's the other side to this that's really, you know, like, I have all of the resources on that side, and I'm voting for this person just based on the part that I care about, which is safety. So I'm not thinking about what brought this person before the judge. Why did this woman steal from a store? Why is this teenager, you know, strung out on drugs and stealing or committing robberies or something like that? They're not thinking about that. They're thinking just about what their needs are, and not what the other side needs. And sometimes that vote can drive the platform of what happens in court. Sometimes, though, organizations like Lawyers for Civil Rights, like the ACLU, do a lot of educating, and the benefit of that and their work is the more the general population is educated about what a prosecutor does and what the vast array of discretion that they have. The ACLU ran a campaign just before the last Suffolk County District Attorney election called "What a Difference a DA Makes." And it really went a long way to educating people about what a difference a DA makes in everyday lives. And I think it really brought people who otherwise might not have voted in a district attorney election in ways that they were now really engaged and understood what and who they were voting for, and they asked questions. And there were panels like this all across the county, and people asked a lot of questions. And I think what's happening now with the progressive prosecutors that Ashley mentioned across the country is that people are asking questions, and we're getting more woke. And we're starting to ask, like in Ferguson, why are Black and brown people having to pay so much money for their freedom? And why are law enforcement stopping people because they owe fines? And why are people sitting in jail because they can't pay that? So that starts a dialogue, and then that propels people to vote. And this is why panels like this and BDL participants are critical to how this all works. The more knowledge and woke you are, the better the system from top to finish or to bottom works.
And before Iván, before you respond, I just want to encourage our BDL students and Suffolk students to drop their questions in the chat. But please, Iván.
Yes, of course. Thank you for that, Professor. I actually loved seeing the campaign, What a Difference a DA Makes, because I felt it was humanizing something that tends to be a bit removed and aloof from the lived experience of most people. And what I want to add to this conversation is the list of low-level offenses that, so-called progressive prosecutors are declining to charge. For example, here in Suffolk County with District Attorney Richard Rawlins, or in Philadelphia, or in other jurisdictions, are not overwhelming. I mean, this isn't something that shocks the conscious. This isn't allowing people to get away with murder. Far from it. We're talking about very minor things that could have significant consequences, especially when we focus on youth, and when we focus on youth of color, when we focus on urban communities where these charges are presented disproportionately against youth of color, building the type of criminal records that have life consequences down the line. I'm talking about just disturbing the peace. I mean, that could be, you're playing a boombox really loud at the park, which is annoying, but should it be criminal? Should that be subjected to criminalization? This concept of rioting. I mean, what is a riot, really? Talk about something that is deeply charged along racial lines. Somebody's protest is another person's riot. And so where you draw the line between First Amendment and other things are things that are quite racially charged, and also charged with issues of class. If something is manifested in the Back Bay versus something manifested, to use an example here in Boston, not just the Back Bay, but contrast that with Dudley Square, Nubian Square, for example. There's also things like receiving stolen property which could happen very often, particularly in low-income communities, where you might be buying a product from somebody not knowing that that is stolen property, or minor possession of alcohol. I mean, these are things that shouldn't be criminalized. These are things that should be treated with substance abuse or substance disorder treatment. I mean, there are professional services, social workers, and an entire line of professional services that are designed to deal with many of these type of offenses. And so when we're talking about not charging low-level offenses and that makes you a progressive prosecutor, I mean, I think that that's the type of lens and filter that should be a given in any type of law enforcement operation, because you want to be sensitive to the effects of poverty. You want to be sensitive to the impact of race, to the impact of living in communities that are plagued by the type of social, really socioeconomic issues that are at the root of many of these proposed charges that would otherwise be escalated and criminalized and send somebody to jail instead of teeing them up to go to college. One of the people in the chat made a comment about how they work on restorative justice issues, which is really great. And I want to raise that in connection with this conversation, because instead of using the criminal justice system to address many of these offenses, I think the restorative justice model is one that gets us much closer to resolutions that are more meaningful, that are more personalized, and frankly, that, you know, wearing the hat of a fiscal conservative for a second, that are also cheaper on taxpayers who don't have to finance the resource-intensive nature of prosecuting, charging, incarcerating, and parole, etc. So restorative justice models, which have been very effectively used in many schools that some of the participants may be familiar with themselves, those models place a conversation, a dialogue between the victims and the aggressors in order to have them understand the consequences of their conduct and to come up with solutions that are tailored to address that particular circumstance. We have used it at Lawyers for Civil Rights extensively, particularly in issues involving youth. You know, a youth is being bullied in school. We set up a restorative justice model to make sure that that victim can address the issue with the bullies so that the bullies understand the consequences of their actions and have actual consequences for their actions. But we're not throwing the book at those people. It just doesn't make sense. And so I just wanted to allude to some of those charges, because I would like to think that many of us in this table right now in the audience agree that these are not the type of things that should derail someone and have criminal consequences, and that there are other models out there that are very practical. And so when we talk about progressive prosecutors in the way that Ashley was articulating so well, I just want to add that lens, which is very practical.
Thank you, Iván. And, you know, that brings us to another sort of area of focus around sort of restorative justice, alternative sentencing, particularly in the case of young people, but also in considering the various circumstances where people may find themselves, as you talked about, where they may commit crimes due to lack of resources or opportunity, or things like addiction. So do you see more need for these alternative sentencing programs? Are there other criminal justice reform issues or solutions that you might expect to evolve at the federal level with the new administration, or things that people sort of can think about how they can be active in pushing for them? And, you know, I think especially love to hear your thoughts, all of you, on, you know, how you envision, you know, a true criminal justice system to look like. So that's a two-parter, so you can, anyone can jump in.
I'll start and just say, I think, you know, in an evolved system, we wouldn't rely so exclusively on incarceration as the response. and we would rely on it almost infrequently, like what is done in other countries. And in the US, we just, it seems to be the first response to everything is we're going to, just punish our way out of this. And it hasn't worked. We have, considerably lower crime than we used to, but all of the experts say that it doesn't have anything to do with how we've responded to the, uptick in crime in the mid-90s. It's, and it's really the policies that got us to this situation of mass incarceration. And the problem, one of the many problems, although it would be a problem either way, but one of the many problems is that this falls disproportionately on people of color. And, I don't know that we would be so okay with the system as it is if, it was the case that, it was disproportionately affecting white people.
I'll jump in to piggyback of what was just elaborated, and I want to actually echo and elevate what Professor McLaren mentioned, which was bail. She mentioned it in the context of Ferguson, but it's applicable even here in Boston and in other cities and places. So, and I'm sure Professor McLaren can go into much deeper detail about this, but I'll just quickly to put it out there. I think that is a huge area, an opportunity for reform. No one should be spending a day in jail because they are too poor to post bail. That is just awful, inhumane, beyond belief. And it's just counterproductive to the use of any metric of the criminal justice system, not to mention its impact on taxpayers. And so to me, that piece is particularly reprehensible and subject to reform. So, so I just want to echo what Professor McLaren said there about cash bail. And then the other piece that I think, just on the subject of reform, in light of George Floyd's murder, it is, I think, for us at Lawyers for Civil Rights, the conversation isn't about defunding the police. The conversation is about how do we right-size police activities, police functions, police responsibilities, and budgets. And I'll give you two quick examples. So homeless outreach, does that really have to be done by a cop? Shouldn't it be maybe a social worker or somebody else who's in charge of connecting homeless people to services? So there's a bit of a disconnect in how we have really come to rely on law enforcement for functions that other city agencies or state services could really be responsible for. So we could take that responsibility away from police and de-escalate those situations, putting a different professional and funding that agency for that work instead of funding police. Another example is what's happening in school campuses. Again, with restorative justice models sweeping through the country, we need to rely more on that and less on calling 911 when there's an incident involving two students, especially something that's nonviolent, something that is just a routine incident in a school cafeteria. People got into a food fight. Sit them down with a restorative justice model instead of criminalizing them. That type of right-sizing of responsibilities, I think, is the future of police reform. So I'll just throw out those ideas because I think that they're important right now as we talk about reform, but also to piggyback of your second question, it's also important to put on the radar for the Biden administration.
I agree with everything that was just said. One thing that sort of resonates with me is something that happened in New York not too long ago. Probation was your typical, what we call trail and nail type of probation department. Their job was to trail probationers, and when they made a mistake, bring them back to court and ask the judge to incarcerate them, or ask for increasing penalties. They not too long ago switched to a client-based probation department. And instead of trail and nail, probation officers were rewarded for success of their probationers. So if they had 20 probationers who successfully made it off probation, that probationer officer was rewarded. And they stopped talking about probationers and they started talking about clients. And these probationers were their clients. What that, and I can report that the success is off the charts almost immediately. More success from probationers. Probation officers are happier doing their job. They're better at it. And the community is safer in that regard. Obviously, there are some people who aren't successful. But what that got me thinking about is, what if that were expanded to the whole system? So if the whole system thought of its users as valued customers and clients, and that whatever that customer and client needs the system to do, it will do. Imagine if judges were aware of the situations that their clients that are appearing before them lived in. If they knew something about poverty, about mental illness, about chemical addiction, if probation officers talked about clients versus probationers, if defense attorneys understood that it is really difficult for people to get from Roxbury to downtown where their office is. And if the system sort of, instead of being its users and its valued customers, if you will, are the people who practice there, if we shifted it to our valued customers are those people who are before the court or who are part of the system, and not the lawyers and the judges and the probation officers, that could be expanded, that notion that happened with probation in New York. The other thing that I think is really important that we highlight is prison and incarceration should only be reserved for dangerous people, not for juveniles who jump the turnstile 10 times and just don't learn their lesson, or for somebody who has like 12 minor non-dangerous cases. If we just sort of really strictly stuck to that, we could probably reduce a lot of incarceration. And then finally, I think the system has to reflect who's before it a lot better than it currently does. There needs to be more judges of color, probation officers, police officers, district attorneys, defense attorneys of color. I'm not saying that we get it perfect every single time, but at least there is consistently a will and a desire to do better and to try better and to understand the communities that we serve. And then finally, just in terms of juveniles, we really need to end long sentences for juveniles, whether it's probation. I don't know a teenager who could do probation for 2 years. It's just not logical. I also think in Massachusetts that the indefinite period of commitment to DYS for juveniles has long since met its time to be gone. A 12-year-old in Massachusetts could be committed to DYS until their 18th birthday. That's 6 years. That is ridiculously long with no review on whether or not rehabilitation has occurred. And I think that's something that's ripe for reform in Massachusetts. And then finally, police officers and law enforcement need to leave high schools.
Thank you for that. And I wonder if either any of you would like to expand on sort of youth in the criminal justice system, and how this system is evolving or isn't to address the unique circumstances of young offenders. And you mentioned, you mentioned a few things, Kim and Iván and Ashley, you've all touched on it. But what can be done to reduce the disproportionate number, disproportionately high number of Black and brown youth that are entering the court and prison systems?
Well, I think, Kim really touches on it by saying the presence of law enforcement in schools is really a requirement for an evolved youth justice system, because anywhere you look, you see the school to prison pipeline, and there's no role for police in the school system. And there's definitely a need for schools to be safer, particularly inner city schools that have a lot of violence. But I don't think that the presence of law enforcement and then all of the, fiscal incentives to have law enforcement in schools has made a difference. And I think, schools with violence would tell you that. I also think, part of the 90s, what it ushered in was the ease with which you could transfer juveniles into the adult system. And even now, the prosecutorial, role in doing that is, there's no limit, and there's no limitation on that. And there's really no data on that. There's a lot of data on judicial transfer and statutory transfer, but it's very hard to know how many times the prosecutor transfers. I don't know what the rules are in Massachusetts for reverse transfer, but in many states, once it transfers up, it's very difficult to move back down into the youth justice system where youth belong. So, there's a lot that we can do to improve outcomes for youth, particularly because some of those early responses that we have in our current justice system really predict involvement in crime later on. So we're not helping, we're actually causing the problem we aim to be resolving.
Absolutely. I fully agree. Ashley hit the nail on the head when she started talking about as she was explaining the whole school to prison pipeline issue, which thank you, Ashley, for raising that. That is critical. And Ashley also alluded to this earlier, and I'll echo it. Ashley mentioned the encounters between law enforcement and youth, which is really the product of racial profiling. And there are so many youth, particularly in low-income communities of color, who are used to those indignities, those day-to-day, come over here, I need to pat you, I need to frisk you. And that happens not just in New York, that happens here in Boston a lot. And so it's those interactions that contribute to precisely what Ashley just elaborated now and was elaborating earlier that I wanted to talk about, because those racial profiling incidents are also at the core of what we're talking about. So it's about disrupting the school to prison pipeline. It's about disrupting the racial profiling scheme that currently exists. And I think there's also something to be said about making sure that youth see themselves reflected in the institutions that we're talking about, which goes to one of Professor McLaurin's points about diversity in every facet, every aspect of the criminal justice system and the legal system. We don't have enough youth of color who see law enforcement as a viable professional opportunity, and bridging that tension, that gap between communities of color and law enforcement has to happen. It has to be something deliberately and intentionally done so that we have more youth going into these professions in the way that has been articulated by the other experts on the panel. I think that's really important, because otherwise we're not having that transgenerational impact when it comes to these institutions, and when it comes to how these institutions view youth. Instead of viewing youth as residents, as civilians, they view them as suspects. And it's really changing that that nexus that is going to be critical. So there's no silver bullet, but I just want to elevate the points that have been made by my distinguished colleagues, which I echo and agree with. And I think those are spot on.
And thank you for that, Ashley and Iván. And I'd love to sort of ask about whether there are things that youth should know about their rights and how to respond to these kinds of interactions with law enforcement.
Oh yeah, I mean, I'll just get started really quickly here, but I mean, everybody should know that they have the right to walk away from a police officer unless they're under arrest, and that they have the right to ask that. And don't be, you know, I'm not going to use my usual vulgar language here. I'll try to behave, but don't be crass. Don't be rude to the police officer. You know, don't be rude to the cop. Be respectful, but you know, you can't say, officer, I'm running late to school. You know, am I under arrest? Because if I'm not, I need to get to this meeting. I need to get to work. I need to get to school. I need to get home. My mom's calling me, right? Like, you can extricate yourself being polite, but, you know, but forceful in saying that, and reiterating that if you're not under arrest, you don't have to continue that conversation. That is one of the most simple things that we need to communicate to youth, so that they are not subject to prolonged interrogations or unlawful detentions, and worse, searches, right? It's like, can I take a look at your bag? And they just grab the bag. And the fact that you don't say no is taken as consent, as implicit consent. And so when they say, I'm gonna take a look at your bag, or can I take a look at your bag, and you don't say anything, that's consent. You have to say immediately, no, I am not authorizing you to look through my backpack. I am not authorizing you to look through my bag, or through you know, my luggage, my car. You know, you say no. You have to say no. And then if the officer continues doing what they're doing, you know, that's on them. But you've laid the groundwork to be able to challenge that legally later. And so just those things right out of the gate can be life-saving for youth. So I just wanted to get out there right there and put them out, but I'm sure my colleagues have other things.
Thank you.
The only other thing I would quickly, or one thing I would quickly add, is never ever speak. If you are arrested, if you are in that situation where they want to talk to you, you do not, under any circumstances, even if you didn't do it, even if you have an alibi, even if your mother or somebody can vouch for you, you do not want to make a statement under any circumstances. I think we've all seen from the examples that Jackney gave at the beginning of this program what a statement can do, and what a confession can do, and how it can be twisted. So under no circumstances speak. And as Iván pointed out, and this is really important, unfortunately, not all engagements with law enforcement go well. And not all people of color end up leaving them whole or safe. So you always want to do exactly what he suggested in having a plan before you're out there. And that plan is just, you know, my mother said, don't speak to you. My lawyer said, don't speak to you. I have to get to school, or I have to get to a meeting, Whether it's true or not doesn't matter, but you always want to have some way and some idea how you can safely disengage yourself. I wish I didn't have to give that advice to young people of color, but we are still realistically living in a world where that is necessary. The other thing I would also say too is also to echo what my colleagues have said before, ask questions. If you are engaged in the criminal or juvenile justice system, you really want to ask your lawyer a lot of questions. If something sounds too good to be true, just keep asking questions. Ask to see things about your case, ask what's going on. I can't emphasize enough collateral consequences and what they do. We get so many folks who want to be police officers, but they have a juvenile record and they can't get a gun license or they can't get a driver's license. So many people who are under the threat of deportation because of their juvenile offense or adult offense, or who can't live in Section 8 housing with their grandmother and now have nowhere to go, or who can't get a student loan and can't afford to go to community college, or law school. So these are all important things that may not seem important in the moment, but I promise you that they are, and that they are things that last a lifetime, and that people do need to think about. And also, I do want to say too, in every state in this country, and particularly in the state that we live in, there are a ton of resources. People like the three of us and others, many, many, and many others, who will answer questions. If you called any law school in Massachusetts and said, I've been arrested, I have a question about what I should or shouldn't do, or should I speak to the police or not, we would pick up the phone, we would answer you, whether you're our client or not. And if you had a lawyer, we would call that person and make sure you got connected to that person. Or we would refer you to a lawyer or somebody who could represent you. There are a ton of resources that are there for the asking, but a lot of times people don't know it exists, but there are a lot of resources.
That's so true. And I love what Professor McLaurin said about don't speak. I think youth in particular are so used to speaking their way out of trouble, talking their way out of trouble, right? Like you didn't do your homework and you talk to your teacher and you're like, but this happened to me and this explains it, and making it go away. Or at home, right? You get in trouble with your parents and you try to make it go away. You talk to them, you sweet talk your way through things. And that's very common for youth, even for adults, right? But in this context, what Professor McLaurin said is so important. You cannot sweet talk your way out of an encounter with law enforcement, which is why staying silent is the best thing to do. Don't have that gut feeling, that gut reaction of, oh, I could just get out of this. You know, I'm just gonna talk to this officer and work my magic. Well, no, that might work for your teacher. That might work for your grandma when she's asking about who ate the last cookie or who drank the milk, but that is not going to work with the police officers. So that is really important because, you know, youth tend to think, and we all did, that you could just get out of it. I could just explain this away, and you could be opening up yourself for a much bigger can of worms because you're talking. And so the less you say, the better. And so I just want to emphasize that because I think for youth, that particular advice is so critical. I mean, my brother thinks he could sweet talk his way out of anything, you know, and I'm sitting there and I constantly tell him, do not talk to the police. Just call me immediately. You know, this even happens within family, right? So I just want to point that out.
Thank you, Iván. I do want to pick up on a thread that both Kim and Ashley mentioned in regards to sort of, right, law enforcement being in schools, and that's a school to prison pipeline. And how do we make schools safer for our young people without bringing in law enforcement? And also, if you are aware of any activism, particularly youth-led, around this sort of eliminating the school to prison pipeline.
So Iván also talked about this too. One of the things that law enforcement in school does is it criminalizes normal teenage behavior. I don't think any of us went to school where either we didn't do something stupid or our friends didn't in school, around school, but having a police officer there criminalizes that behavior. So technically, when I was throwing toilet paper out of the girls' bathroom when I was in high school, I was probably defacing property. Had there been a police officer there, maybe I might have been arrested, depending on how that person felt that day. In my clinic, the Juvenile Defenders Clinic, Iván brought up the scenario of two kids having a food fight. We've had that 3 times where literally kids will come in, be brought into court by school police officers in hand and leg shackles for a food fight. That is wrong. And now they have a record, or they're known. And as Ashley said, that perpetuates itself. And it becomes not only how their high school community sees them, it now becomes how the court community and law enforcement community sees them. And worst of all, it sometimes becomes how they see themselves. And that is criminal in and of itself. So getting rid of law enforcement in a place of learning is critical. I will also say too, students police themselves better than we can. They do a better job when they set up peer courts or peer systems, restorative justice, as we talked about. When it involves teenagers helping other teenagers within their communities, they do a better job than the adults do in external courts. Youth courts that are run by teenagers with the assistance of adults do far better in terms of rehabilitation and recidivism than our typical juvenile courts do. We know that services for kids who are struggling are much, much more effective than probation or incarceration. So more of that, as Iván and Ashley have said, writing the system. So instead of spending so much money and time and effort on incarceration, can we spend some of that time and effort on schools and on diversion and on alternatives to incarceration? And then finally, I would take all of the money that we're going to save from getting police out of schools and funneling that back into the school. So rather than having 10 law enforcement officers in their school, maybe they have a field where they can play baseball, or maybe there's a new art studio, or maybe there's a computer science lab in that school instead of law enforcement.
Thank you. I know we have some students listening in, maybe they're a little shy, and you all have already, I think, talked about a number of things, but I still want to ask, if you had the opportunity to teach students in middle and high school, because I think sometimes high school is the first encounter for some people, sometimes it's middle school where they have this encounter with the criminal justice system, and they just may not know sort of, right, they don't have that understanding. So what would you teach students, middle or high school, about the criminal justice system, and what would you want them to know?
I confess this question really stopped me cold. My honest answer is I don't want them to know anything about it as a user. I would, there's nothing good I could say about the system from that end. I think we've said some of it, that it's involvement isn't a temporary thing. It's not designed for that. It is designed to keep you within that system once you're in. And it is designed to be with you. There's rarely a situation where someone comes before juvenile court and a case is filed and seen to the end, that's it, that, it miraculously goes away. That's still really difficult for adults and juveniles, as we've seen throughout the country. I hope someday that the system will evolve to a system that is designed or develops into a system that helps people, but I don't think we're there now. So that would be my answer, I guess, if I were forced to answer that. But my hope would be that we stop seeing so many people of color, and then people, period, involved with this system. It isn't a system that is designed to help people.
Yeah, I also was, that provoked a lot of careful thinking from me to see that question. And I guess if I were to teach students who, didn't really know anything about the system at this point, I would start, by asking them, sort of what they think the system is, and if it, and I guess I would try to educate people without biasing them too much, that it isn't a blind, we don't have a blind justice system like we think we do, like we're taught, that justice is blind, and that by the time you get into the courtroom, everything will just sort itself out in the fairest way, because in the reality that it just doesn't happen. Everybody in the work group is a human being, and has their own personal biases, direct and indirect and explicit, that they take into those decisions. And then, we as a country, we have a very long and complicated racial history, and that is intimately involved in our justice system, and so I think that that's important for young people to know, that it's not as if all of that history just moves to the side when we're deciding the facts of a case. It just doesn't happen that way in this current system that we have.
Thank you, Ashley. I think that was really powerful to make the connection with the racial history in this country. And I wish that, frankly, I wish that kids had, at all levels, whether it's elementary school, middle school, high school, had like a like a more anti-racist curriculum that talks, for example, of how some of the early slave patrols are essentially what evolved into some of the early police departments, right? And so making that connection between slavery and policing, for example, the policing of Black bodies and the contemporary policing of Black bodies, I think could be really powerful to raise more public awareness and consciousness around these issues that are deeply layered with race, with class, with gender. And I think aside from some of that type of reality check, like very real, historically based information, a lot of the practical things that we've been talking about here, like to talk about how a restorative justice model works, to talk about what are your rights when you are confronted with a police officer. Those are practical things that should be taught in schools, just like, how do you vote? And how does a bill get passed? And unfortunately, we've removed so much from public schools in particular, where kids no longer have civics classes. Kids don't have an understanding of the democratic framework in terms of how our democracy functions and the vital role of an active and well-informed citizenry. Those are things that I think all kids need to know. But I will add one more thing, which is I think a lot of these lessons are not just for youth. I think a lot of these lessons are also for adults, for law enforcement officers to understand the consequences of their interactions with youth, for teachers to understand exactly what Ashley had mentioned, the school to prison pipeline, and how giving a kid an out-of-school suspension places them at substantially higher risk of getting involved in the school to prison pipeline and the criminal justice system down the line, right? So the connection between what may be routine action in a classroom or routine law enforcement activity has these real world consequences. And so I think we need to have these conversations, not just with youth, we also need to have the conversations with the youth who are in the orbit, in the ecosystem where youth inhabit, where youth get educated, where youth are active in, because I think that disconnect, Ashley's talking about the school to prison pipeline, and I just don't think that your average teacher understands how classroom conduct triggers that, the role that they can play in that pipeline. Like, what is my role in that? And I think adults need to understand that too. So I think that, yes, there are lessons for youth. Yeah, youth need to know that they could say no to being stopped by a police officer unless they're under arrest. But teachers also need to know the consequences of calling the cops on their students, right? So I think this is a two-way street. So, I want to be clear that there are lessons all around and that it's not just one directional to youth, like you're the one who needs to pick up this stuff. No, like it's also us as adults need to make sure that we are fostering the best environment for youth. I hear so many people, and with this I'll shut up. I hear so many people talk about there's no, youth are not politically engaged. And then I'm like, did you see Bernie and the way that they came out for Bernie and supporting Bernie and feeling the burn and all of that? And I'm like, those were 18-year-olds. So what do you mean that youth are not politically engaged? Just because they're not supporting what you support doesn't mean that they're not engaged. And so I think we as adults need to sometimes adjust our filter to make sure that we are in tune to youth and not force youth to be in tune with us. So I just want to put that out there because I think it's good to have that transgenerational conversation.
That's a really important point. If I could just add one thing to that Iván is absolutely right. I'd take it a step further. We have a criminal justice reform bill in Massachusetts because young people protested. And young people, after George Floyd died, marched to the State House in Massachusetts. They petitioned. They advocated, they yelled, they screamed, they got people to write op-eds, they wrote op-eds, and we jumped on board. But I really do think that it is something that when the whole community comes together, sometimes we're led by youth, and often these types of movements, as Iván said, are often led by youth. And when all of us sort of jump on board, things do happen. It might happen slowly. I hope it doesn't take another death like George Floyd's for the next criminal reform bill to happen. But they do happen, and you do have a lot of power.
Thank you so much. I love ending on that note, Kim, that the youth do have a lot of power, and they've proven that. Thank you to our panelists for this evening. We have, I've been watching my colleagues jot down their quotes, and so we've got we got a lot out of tonight. And I just want to thank you, all of you, just for the different points that you brought in. We really learned a lot, I think, about the fact that prosecutors really do have wide discretion. And so that's something to keep in mind. I think, Ashley, I appreciated you pointing out that, states got themselves into this situation around mass incarceration. And so there's an opportunity at the state level to push for changes. And just thinking about better ways to utilize resources. Both Iván and Kim, how do we better address our societal problems instead of using police, right? And this call for youth to really know their rights. And I appreciate everything that we've talked about here tonight. And so I thank you. I thank our audience for listening in. I think everyone was riveted by what they heard. I saw some comments. And I just want to, to our audience, thank you. And you will see a survey link in the chat. So please take a moment to respond to that. And if you are interested in learning more about the Boston Debate League, you can visit bostondebate.org. And if you're really excited by this conversation, definitely take a moment to check out our volunteer page. We have student tournaments actually happening this weekend and next. And so we'd love to have more volunteers participate. And also, if you're interested in the first conversation in our series, you can also find that by visiting our page at bostondebate.org/REP series. And this series will also be going up on our website next week. And we really do hope that you continue to join us. Our next conversation will actually be our January conference on criminal justice reform. So we hope you can join us then. Thank you again to our panelists. Thank you everyone for joining us. I hope everyone has a wonderful evening. Thank you. Have a good night.